morning. So I've got 8:30 on the dot. I think it's time for us to get this started. I would like to welcome you all to the Sobel Co. Employee Benefit Plan Audit Group Fall Webinar. For those of you who don't know me, I'm Liz Harper, and I'm the partner in charge of our EBP Audit and Consulting Group. And here at Sobel, I'm really proud to share with you that we audit close to 90 benefit plans. And we also do work from a consultative nature as well. I am really glad that some of our clients today and service providers that we work with are able to join us this sunny morning. So happy Wednesday. Just a few housekeeping items before we get started. If you look, you will see a chat feature and also a Q&A section. I'm asking everyone to please enter your questions into the Q&A, and we will definitely take the questions throughout the program and also open the platform up for further questions at the end of the presentation. So now I'm really proud to introduce you to our presenters today. So Christine Gottsman, I've known her for almost 10 years, probably around 10 years, and we have several mutual clients that we work together on. When I think of an ERISA attorney, I always think of Christine, and she definitely works with all types of retirement plans, including non-qualified plans. And she helps clients with plan design, compliance with ERISA, Department of Labor compliance, really hot topics. So I'm so glad to have Christine join us this morning as a presenter, along with Abby Nadelson. She is also at Nook Freeman and Sarah, a partner there. And Abby deals with a lot of management type issues, employment issues, as well as one of the hot topics she's going to cover this morning is cybersecurity, which I think personally impacted me last weekend. It's an extremely hot topic, and I really look forward to hearing some of the tips on that. So today, we just ask you to keep this interactive. We really welcome your questions, and we thank you so much for joining us for the presentation. Thank you.
So thank you, Liz. That was a very nice introduction. As Liz said, Abby and I are employee benefits attorneys at Nook Freeman and Sarah. We have a wide practice. We help large clients, medium clients, small clients navigate the employee benefits world, including qualified, non-qualified plans, and welfare plans. So this morning, we thought we would focus on 3 different areas: missing participants, cybersecurity, and fiduciary oversight. And the reason we picked those 3 topics is that we have seen DOL audit activity in all 3 areas in the last few months. I will say that in the last few months, I've seen more DOL audit activity than I saw the whole Trump administration. The Department of Labor is clearly out and very active. And particularly in these 3 areas, we have seen their engagement. So it's really important as plan sponsors and people that help plan sponsors to be aware that there is a heightened scrutiny going on in the government right now. I'm going to start with missing participants, and then Abby's going to discuss cybersecurity, and then we're going to close out with fiduciary oversight. So missing participants, this is not a new problem or a new area for anyone that works in the retirement plan space. It has been a perennial headache for many plans, particularly when the plan is required to make a distribution. So that is when you have small account cash outs that are required to be made, and for some reason you can't find the participant. Very often it comes in case when somebody is required to take a distribution because they hit age 72 now is the minimum required distribution, and you can't find them. So there's 2 prongs to how you handle this issue. One deals with, well, how do we deal with the money, right? Do we forfeit and reinstate, which is what many plans do for the small accounts, Do we reestablish the account if we can't find the participant and just leave it? Do we roll over to an IRA if it's within the 1,000 to the 5,000 level? Do we transfer a taxable savings account? Those are all approaches that plans take. It's important to document in your plan how you handle that. And the Department of Labor has some opinions about that, but their main focus is that they want plans to and plan sponsors to be aware that even if they know how they handle the money, they have a responsibility to find the participants or to try to find the missing participants. So they have a long history of including this item on plan audits, particularly in the defined benefit space. But I think that's going to change in light of their recent guidance, and it's going to expand more into the DC space. Is my guess. It's important to realize as a plan sponsor that the ERISA fiduciary standards apply. So it is a prudence standard here. That is why many practitioners, myself included, worry when a plan would like to escheat to the state or turn it over to the state for these smaller accounts. You can clearly do that if you have a terminated defined contribution plan. That's especially permitted in a safe harbor issued by the Department of Labor. But there are fiduciary concerns when funds are escheated, particularly because it could trigger tax that maybe wouldn't be necessarily triggered in the case of a rollover. So that's something to bear in mind if you were thinking about trying to do that. So for years and years and years, we didn't have very much guidance at all. We had a very brief regulation from the IRS saying, if you can't really find the participant for the minimum required distributions, we won't disqualify your plan, provided that you at least try to find the participants. And they gave some pretty high-level guidance on that. And the only other guidance, official guidance we had from the Department of Labor was a field assistance bulletin. And those are issued really to the agents, but we all take them, we all look at them and review them because they tell us they give us sort of good marching orders as to what the Department of Labor is looking at. And they had a field assistance bulletin issued in 2014 that dealt with terminating DC plans, but that was all we had. So we all relied on that as well. That all changed in the last year. The IRS issued two revenue rulings, a revenue ruling and a revenue procedure, and the Department of Labor also issued three pieces of guidance. So I thought we'd go over those quickly because they did give us quite a bit of color on going forward in this area. The revenue ruling dealt with when amounts are escheated. And again, that is permitted in terms of a terminated defined contribution plan. And though I guess there was an open question as to how you should handle it. And they said the amounts should be taxed and 1099s should be issued. But they also clearly stated, they have a big footnote in this revenue ruling saying they are not taking a position on when a plan can escheat. That issue and guidance is in the DOL's purview. So it's important to remember when you're working with retirement plans, that there are two agencies involved. There's the IRS and the Department of Labor. They try very hard not to cross into each other's space. The IRS deals really with the money side of it and the qualification requirements for retirement plans. The DOL is primarily concerned with fiduciary oversight, and that includes things like delinquent contributions. So the IRS said, we'll tell you how to tax it when you escheat it, but we're not telling you that you can do it or when you can do it. That's going to be from the DOL. They also, in the Revenue Procedure 2020-46, did add escheating to the state as a valid reason for a waiver of the 60-day rollover request. So that all happened at the end of 2020, and everyone was like, well, maybe we're going to be able to escheat to the states. Maybe that's going to be something we can now do. Then the Department of Labor came out with their guidance, and they came out with three pieces of guidance in January of this year. They have a best practices memo for reducing missing retirement plan participants. There's a compliance assistance release that technically only applies to defined benefit plans, but is full of lots of insight and clearly was issued with the idea of helping us in defined contribution plans as well. And they also issued a field assistance bulletin, basically saying that terminating DC plans can also transfer accounts to the PBGC missing participant program. So that has been opened for defined defined benefit plans, the PBGC is third agency that deals in the defined benefit plan space. But now we can transfer missing participant accounts to the PBGC. That's actually really good, because when you transfer to the PBGC, you do not trigger a tax implication to your participants. So I thought we'd spend some time going over the best practices memo and the compliance assistance release. As I said, they are long and they are chock full of very explicit guidance for us, which as an attorney, I'm very thankful for it, because it really, instead of me trying to figure out what the Department of Labor wants us to do, it's very nice when they give us this guidance. With that said, I've been asked several times, and we also have, Abby's going to go over best practices in the cybersecurity space. They also issued that. It seems to be a new approach for the Department of Labor to issue guidance. A best practice is not a regulation, right? It's not binding on plan participants. They're not saying you have to do it, but they are saying this is what we recommend you do. I think there's a very thin line between that, because if you get audited and you don't follow their best practices, I'm not sure that it's going to, there is a lot of wiggle room there. Although they do acknowledge in these best practices memos that it's not going to necessarily be one size fits all. If you have a small plan, you may not, and you're a small employer, you may not have to check off all the boxes. If, however, you are a large plan and a large employer, my strong recommendation is you're going to want to check off all these boxes. But they've given us boxes to check off now, which is really, helpful. So there are several things to mention about this best practices memo for missing participants. It applies to both DC and DB plans, and not just terminating defined contribution plans. It applies to all 401ks, 403bs, defined benefit plans, the whole spectrum. It also technically could apply to welfare plans. Those usually don't have accounts, but that also is within the scope. As I said, they do indicate that you can balance costs and benefits. And but as I said, I think it really depends on the size of your plan as to how much you can do that. So there's 4 sections in our best practices memo. Section 1 deals with maintaining accurate census information. So this is really, really important from a functional standpoint, because as I've seen, and I'm sure Liz will agree, once you have somebody that's been missing for a long period of time, it just becomes harder and harder and harder to find them. You may never be able to completely check them off. So it's really important to minimize your risk on that level. And that includes things like contacting your participants and beneficiaries periodically, making sure that it's super easy for them to change their contact information. If you get mail back or an email bounce back or an uncashed check, certainly it requires follow-up. Making sure that online platform is easy to access. They recommend regular auditing and correcting of census information. And in the mergers and acquisition context, please, please, please make sure that you get the participant and beneficiary information transferred over from any plan that is being assumed if you're the purchaser. The Department of Labor made a strong point in this guidance that where they see a lot of these misses is a result of mergers and acquisitions, where one company gets sold to another company, the purchaser plan merges the seller plan into their plan, but they don't keep accurate information of any terminated vested participants coming over from the old plan. And again, that just makes it really, really hard to go back and fix that. Section 2 deals with implementing effective communication. They say use plain English and non-English language assistance where appropriate. You want to clearly state the purpose of the communication. You've got to be really careful on onboarding and exiting processing to make sure you're getting contact information. When you send out information in the mergers and acquisition context, you probably want to flag for terminated vesteds the name of the employer that they were employed by, not necessarily the new name of the company that has taken over that plan, because it may not resonate with them and they may just trash it.
Christine.
Yes.
Quick question. So Brad Munez is asking, the state of New Jersey requires a sheeting. So the Department of Labor overrides or supersedes the state requirements. I guess, can you just clarify that?
Absolutely. So the Department of Labor takes the position that ERISA preempts state law, including the sheeting laws.
Excellent. Okay. Thanks. And really thank you for honing in a little bit on those merger and acquisitions. We definitely have clients that have transfers in of funds. So it's really important to, I guess, really stress the importance of the fiduciary role for the plan sponsor that's bringing on those new participants, and the importance of making sure that that census data is accurate.
Absolutely, yeah, no, and you know, this guidance from the Department of Labor is great because they make very clear where they're seeing the problems when they're going into audit.
Great, thank you.
Sure. So Section 3 is missing participant searches, and they sort of list all the different ways you can find. They think you can find people. Some of them I like. Some of them I like a lot. They're great. And some of them I'm like, well, let's put a little asterisk around some of these. So the first step is an obvious one. Check to see if you have participant information in your other employer records. So you may have it in payroll. You may have it in your group health plan. You know, if you've retiree medical, would be a great place to check. And that's easy enough. Check with the designated beneficiaries for updated information that they may have. There are free online search engines, public record databases, obituaries. They recommend, if you want commercial located services and certified mail or a private delivery system. Those obviously cost money. So that's something, particularly if you're a smaller plan, that may not be feasible. They say attempt contact via email, telephone, text, and social media. So the social media is the one that gives me pause, because I think you have to be super careful about going out in social media and trying to track down people by telling them that they have money in their pension, because I think you risk exposing the plan and those participants to fraud. Someone could see those posts and say, well, that's great. I'll just pretend to be John Doe and get my pension from XYZ company. So there is a little sprinkling of common sense that's going to go on in here. And just because they put it in this guidance doesn't mean that you don't have to be careful about other risks and other concerns. They recommend the death search, which is a Social Security death index. That's, again, an easy thing to generally find. Reaching out to colleagues or publishing the list of missing participants on the company intranet. Again, I have the same concern there with the privacy and the potential for fraud. Obviously not as much on the company intranet. You'd like to think your employees were honest, but again, I'd be a little cautious about that. Obviously, if union employees, contact and work with the unions. And then there are public and private pension registries, provided that they have the privacy and cybersecurity protections. And one that the Department of Labor called out specifically is the National Registry of Unclaimed Retirement Benefits. The fourth area of this guidance deals with documenting procedures and actions. And I love it when they do this, because I feel like I spend my life telling my clients, please, please, please document decisions. Put it in writing, make sure that if we ever get audited, we can pull things out of a desk. And it's not necessarily that you have to get it right, but you have to follow procedure. In ERISA, process is everything. Process is everything, provided you're following the steps that the government lays out for us. So they want you to put in writing the procedures and the timeframes. Document key decisions and steps that are taken to implement policies. And that's true of anything in ERISA. The third one is really important, I think. It says use third-party record keepers, which basically everybody does. Work with the record keeper to understand any shortcomings and procedures used by that third party. So this has come up recently for me with a client, where the client thought the record keeper was doing more proactively to find people than the record keeper the record keeper wasn't doing anything. This is in the context of a non-qualified plan, but the same does apply to some extent in the DC and the qualified plan space. we have to realize that the record keeper interests are not necessarily aligned with pushing money out the door and getting participants off the rolls. They're not a fiduciary, so they're not required to act as a fiduciary in this respect. And very often, the fees that you pay are based on number of accounts and assets under management. So it's important to, I'm not saying that they're nefarious in this respect, but as I said, their interests may not be completely aligned with you as the plan sponsor to take the fiduciary actions that the DOL has laid out here and go find those missing participants. So it's really important to engage with your record keeper and make sure that what you think they're doing, and that they understand what you want them to do in terms of finding missing participants. Very often, for a fee, they'll do a really nice search and provide a nice report. And if you're a larger plan or a mid-sized plan, that might be worth doing, particularly in light of this new guidance. So now I'm going to move on to the compliance assistance release. And this, as I mentioned, this came out again early in January 2021. It applies to the terminated vested participant project. And although technically that's only for defined benefit plans, it gives us a wealth of information. And so it's important as plan sponsors and people that help plan sponsors to understand what triggers these sorts of audits. So the Department of Labor lists 3 things that they say are triggers for audits. Large number of terminated vested participants reported on the 5,500. The plan sponsor being in bankruptcy, or they know that they're in active mergers and acquisition roles. I thought that was particularly interesting. I have a client, I'm in a situation where I'm advising a client that acquired the assets of an extremely distressed company. That extremely distressed company has a 401k plan that has been under audit and has serious problems. And it's at the point now where the Department of Labor, which I've never heard this before, is actually recommending they shut down the plan. I've actually never had the government recommend that a plan be shut down. So you can only imagine what bad shape that plan is in. But it's interesting that they definitely identify bankruptcy as a trigger for these audits. And also, obviously, participant inquiry to the Department of Labor. Anytime you have a participant call the Department of Labor, they're probably going to turn around and call you. So information the Department of Labor is going to ask for in the TVP audit, but this is really true of almost any audit. They're going to ask for the plan document and SPD. They're going to ask for participant census records. They're going to look at actuarial reports. They're going to look at the plan procedures for communicating, and they're going to look specifically at the plan procedures for addressing missing participants. And they're going to include interviews with that. These are really full-blown audits. I work with an actuary that he and I work together on a defined benefit plan that's in fine shape, but he's advising another client where they have been under this TVP audit for literally 4 to 5 years, and they cannot get out of it. They have a very diligent agent. They have done a lot, if not all of the things that are on the list. They still can't find enough of the people to satisfy the Department of Labor. So to the extent that you can minimize your exposure, because once the Department of Labor is in your plan, it's really hard to get them out. So the goal is to not trigger an audit at all. They also, in this guidance, go through what you're going to expect in an audit. And this is also really gold because it follows exactly what they do with any kind of audit. You're going to have an initial letter requesting documents. There's going to be a follow-up letter. If you are not responsive, the DOL will issue subpoenas. I cannot tell you, I'm sure it's common sense, that if they get to the point of issuing a subpoena, you are in trouble. That is not a step you ever want the Department of Labor to take. It is also, if you ever get a letter from the Department of Labor, the first thing you need to do is act on it. If you have ERISA counsel, reach out to ERISA counsel. I will always engage quickly when I have a client, and we'll talk a little bit later about this in the fiduciary oversight area. It's important to respond quickly to the Department of Labor. Let them know you got the letter. We have a situation with a client that the Department of Labor sent a letter regarding COBRA compliance They tried 4 or 5 times to reach this client. Nobody ever got back to them. So finally, they found and called the one of the plan administrators at home at 7:45 in the morning to follow up on their request. Luckily, they didn't get to the subpoena level, but again, you just don't want to start off with the Department of Labor being aggravated with you. So it's really, really important to follow up with them. What they said they're looking for systemic errors in record keeping and administration. They're looking for inadequate procedures for identifying and locating missing participants. They're looking for inadequate procedures in contacting terminated vested participants as they near retirement age and as they near the required minimum distribution age, which is now 72. They're looking for tax information to be included, and they also want to make sure that you have a procedure for addressing uncashed checks. They also listed a whole bunch of red flags. So this is really, if you know in your plan you're doing any of these things, we should correct them as soon as possible. So for example, if they see a lot of missing and incomplete participant data, with, for example, placeholder birth dates like 1/1/1900, I've seen names that John Doe that are clearly, we don't know the name of the participant, that's a big red flag for the Department of Labor. If you're getting mail returned and you're not following up, that's a big red flag. If you have a high number of terminated vested that are not in pay status, and again, they're going to be able to find that out from the 5500, that can be a red flag. Continued communication to known bad address. Don't keep sending letters and emails to addresses you know are not good. They expect you at the very least use simple verification services and services that can be provided by the plan record keeper. If your notices are not in plain English. And this, actually, I've never seen this, but if you have a planned practice of deleting missing participants from the census, that is a big red flag. You can't just erase them and have them go away. That's not how it works. And at the very end, they talk about, well, how are they going to close the audit when they're finally done? God willing, they're finally at the end of the audit and you've managed to get through it. They're going to start, as I said, with requiring corrective steps of the plan sponsor. They may and they probably will issue something called a voluntary compliance letter that lays out the ERISA breaches. This is kind of a scary letter. I've had clients get it. It usually goes, these are all the ways that you breached your fiduciary duty under ERISA. They list them out, and at the very end, then they'll say, but nevertheless, you took all these steps, so we're going to close the case. That's good. As I said, the first part of the letter is very scary. What they did indicate, and I thought this was very helpful, they will not include individual plan fiduciaries. Now remember, if you are individually plan fiduciary, so if you're a trustee, if you're on the retirement plan committee, you can be personally liable. But they said they will not include you in those audits unless there's especially substantial errors or widespread breaches. And even in the case of the plans that I was mentioning earlier, the one that they are actually actively trying to shut down, they have not gone off. There's one plan fiduciary that stole money from the plan, so they are going after him. That's really a criminal case. The other plan fiduciaries are not on the hook personally in that case, at least with respect to the DOL. They have indicated that they will engage you in meaningful discussions, and that's about as fun as it sounds, about breaches and corrections. And once the DOL is satisfied that the corrections have been made, they will finally close out the case. So on that note, I'm going to wrap up the missing participants. If no one has any other questions about how to handle that and the new guidance that we've gotten from the Department of Labor, and I'm going to hand it over to Abby.
Excellent.
Thanks
so
so much.
Abby, really quick, we do have one question, but I think we're going to address it towards the end because I believe that some of the slides when you talk about fiduciary roles and duties will sort of cover some of the common issues that bring a plan to audit. As you mentioned, one being an inquiry by a plan participant to the Department of Labor, but other common issues, we'll circle back on that. So thanks, Brad, for your question. Thank you, Abby.
Thanks so much. And as Christine had alluded to in her presentation, this other area of cybersecurity has been very active within the Department of Labor. Earlier this year, the Department of Labor issued, for really the first time, guidance on cybersecurity as it relates specifically to benefit plans. Before this guidance was issued, many plan sponsors may have looked to other areas to try to understand what responsibilities were. A plan fiduciary included in their duty of prudence under ERISA, they need to be able to ensure that they are selecting and monitoring plan providers, and they need to make sure that they're protecting plan information from breaches, including cybersecurity breaches. So it always had been difficult for plan fiduciaries, plan sponsors to really understand what this responsibility entailed, aside from, a very general business standard. This guidance that was released back in April was very well received, and is really a starting point for plan sponsors and fiduciaries to be able to understand their role with respect to securing their plan assets and their plan participants. Sorry, I'm having some trouble moving the slide.
You want me to move it for you?
Yeah, would you mind? Thank you.
I think we went too far. There we go. Is this the one?
Yeah, thanks so much.
You got it.
So the focus on cybersecurity really came.
Oops. Oh boy. I did something wrong here.
Oh,
there we go. Sorry about that.
Oh, perfect. Now I have my pointer too. So the Department of Labor really, the focus on cybersecurity is based on the substantial number of people and the number of assets that are involved with respect to benefit plans. Focusing on this area and how vulnerable this area could be to cybersecurity attacks is really what helped the DOL focus in on providing this guidance. And to be more specific about the guidance, there were 3 items that the Department of Labor published. First, they published tips for hiring a service provider. This is really targeted for plan sponsors and fiduciaries, and really gives a roadmap for those individuals to be able to ask their service providers the right questions, to be able to work with their service providers, to be able to understand and select service providers that can meet their needs based on their specific employee population, their specific type of company, and their specific needs with respect to their benefit plans. This guidance also included specific items that should be included in service contracts. This includes the responsibility for the service provider to conduct third-party audits to make sure they're in compliance with security policies and procedures, clear provisions on the use and sharing of information and confidentiality, clear notification of cybersecurity breaches. This would include the service provider committing to promptly notifying the employer, the plan sponsor, fiduciary of any cyber incident or data breach and addressing it as it comes up, compliance with record retention and destruction, privacy, and information security laws. And so this would cover all laws that would be applicable to that particular plan. And finally, including insurance. A lot of these items we had regularly been advising our clients to make sure had been included within service contracts. But this guidance that is backed by the Department of Labor really gives plan sponsors clarity on what they need, and really makes the conversation a lot easier for all parties involved to be able to make sure everybody's on the same page. Finally, also the service provider should really be able to demonstrate their commitment to complying with all of the DOL guidance and any DOL audit that may come up for the plan sponsor. The next piece of guidance that the Department of Labor published was cybersecurity program best practices. This is really targeted towards service providers, and many of the items that are included in this guidance were likely already in place. They advise to have a formal, well-documented cybersecurity program, conduct annual risk assessments, have strong access control procedures, encrypt sensitive data, have a reliable third-party audit of security controls. And some items may need to be added or adjusted or modified to comply specifically with the needs of benefit plans. Programs may need to be updated to account for evolving best practices. The guidance specifically requires that there are assigned information security roles and responsibilities. And this may be something that a plan sponsor and fiduciary is looking for in their service provider. There's now guidance that strongly suggests that there should be periodic cybersecurity awareness training. Again, this may be in place, but this may need to be adjusted to address specifically benefit plans. Have an effective business resiliency program addressing business continuity, disaster recovery, and incident response, and appropriately respond to any past cybersecurity incidents. This is not just covering going forward. This is really being able to address what has happened, use it as learning experiences, make sure if questions are asked by plan sponsors and fiduciaries about what may have happened in the past and what has been done to address those concerns, your service providers are prepared to have those conversations. And finally, the third item of guidance that was published are online security tips really geared towards participants. Again, these are maybe intuitive, but many participants really may need to be told and instructed to be more careful with their accounts and take action to make sure that they're protected. Some of the guidance includes registering their online accounts for individuals who have never done so in the past, use strong and unique passwords, multi-factor authentication, keep information current, as Christine mentioned before, helpful for all parties involved. Be aware of and educated about types of phishing attempts. Make sure you report incidents of theft. This is, if there's an issue that involves your account, it may affect other members of the plan as well. And also, training should really be provided for participants so that they can adequately protect their accounts and their plans. One area where we have really seen this, our firm, in addition to our benefits and our employment counseling work, we also partner with a large insurance company to assist in investigations into fraud. And we have seen, I would say, an explosive amount of attempts to access benefit plans and a calculated effort to go participant by participant. And many of the incidents that we've seen involve many of these areas that the DOL has touched upon. Individuals that have never registered their account, that's an easy area for somebody to come in, register the account, and request a distribution. Making a call to a customer service representative who, being able to, weasel your way into getting access to the account, just having a small amount of information. So to the extent that participants are really passive with respect to their plans, they need to be told that they could lose everything, or they can really be at risk. So very minimal effort on their part can really help protect them and go a long way. So technically, this is guidance, as Christine mentioned. This is not a legal requirement, but we are advising our clients to treat this as a legal requirement. Again, the DOL is expecting, since this is out there, that this should be reviewed, implemented, used. To the extent it needs to be modified based on your specific situation, your company, your workforce, that is okay. But this is here for you to be using. And along these lines, there's been very aggressive audits going on in this area since June. There have been really probing requests for information in this area. And the way to respond to this will be by providing your documentation of your compliance with the DOL guidance that has been provided. So again, this goes towards maybe this is not a legal requirement, but you are going to be held responsible to have documentation of your efforts to comply should the DOL come in. There is less guidance here on what the DOL will be doing in this area. These may be more targeted, and they may evolve as time goes on, and as organizations get more capable in being able to implement these controls, as service providers are more aggressive in outreach to their clients and to plan sponsors about making sure that they're in compliance and working together, so that this is a really collaborative process, so that everybody can be protected and everybody can achieve the best results together. The audits are likely to be similar to the structure that Christine had mentioned before, a letter requesting documents. You don't want to get to that subpoena stage. You want to respond immediately. You don't want to expand it beyond what they're asking. The items that you may have to produce are all of the pieces of guidance that we discussed before. Evidence of training, evidence of your programs, evidence of your efforts for communication, your review of contracts. What does your service agreement look like? Have you implemented, have you added this additional provisions that were suggested? And the areas that the DOL is likely looking at is, are you giving this any attention at all? Are you giving this adequate attention? Are you working with a service provider that is able to provide you with the protection that your plan needs? Are you communicating with your participants? Are there any concerns that your participants may not know about, that you haven't brought to their attention or given them access to training about? And again, because this area is evolving, there may be, meaningful discussions going on about what you should be doing better. Maybe some expectations that changes occur immediately before any audit is closed out. But in the end, these audits are really going to potentially go deep and broad. We have clients, especially our big clients, who are being really proactive and reaching out to their service providers and providing them with information requests, making them take a position and give them the information that they need so that they can create that paper trail to document their process and make sure that everybody is protected in accordance with all of the published DOL guidance. So here, the real key takeaways from all of this guidance is that there needs to be a review of cybersecurity programs. It should occur as soon as possible, and it should be ongoing. Plan sponsors and fiduciaries should be working with their service providers. Everybody should be in alignment in their efforts to be able to protect plan participants and plan assets. If there are any gaps in security that are found, they should be addressed promptly, and changes should be made immediately. The program should be documented, and it should be in full alignment with the DOL guidance to the extent it can be. Plan fiduciaries should also be analyzing their service provider programs and updating their service agreements. This is usually done on a periodic basis, but this is an opportunity where plan sponsors really need to take a look and make sure that they have everything in there that they need. Of course, reach out to counsel. Counsel can help make that determination, see if what you have in there is adequate to address all the recommended additions that the DOL has recommended. And finally, make sure that participants are informed about what's going on with respect to cybersecurity in this space. Usually participants, if it isn't for outreach efforts and communications, participants may not know any of the risks until they hear a story of or become the target of some sort of fraud in this space. A lot of information is out there. I know that a lot of service providers are providing resources for plan sponsors to use and to pass on to their participants, but this should definitely be given attention so that participants know that there are things that they can do to protect themselves and their assets. This area will continue to evolve. Fraudsters, as we call them, continue to get more savvy, and I wouldn't be surprised if the DOL continues to issue guidance, expands on their guidance, helps plan sponsors and fiduciaries be able to protect their participants and their assets in the way that they should be, to be able to fulfill their fiduciary duties. All right, I'm passing it back to
So
Christine.
Abby, before we get started, really quick, you use the term service providers. Can you just clarify, because we do have plan sponsors on the webinar, I think of those as the payroll providers, as the record keepers. Is there anyone, can you just clarify that those are what you're thinking, and is there anyone else that I might have missed? Because it's really important to get to that, those details. Thank you.
Sure, of course. So a lot of times benefit plans will be administered by a third-party administrator, and those would be the service providers that would be holding the information relating to the plans, administering the plan, making distributions, administering elections, really taking all actions relating to the plan. And a lot of times plan sponsors, fiduciaries will really engage the service provider, engage the administrator, and really rely on them to do everything that they should be doing. We've found in our practice that that's not always the case, as I'm sure many on listening in can agree to as well. And this is just another area where it really is outside the comfort zone to really understand what kind of cybersecurity protocols should be in place for an administrator. So laying this groundwork, having this roadmap as to what you should be expecting from an administrator who's holding on to sensitive employee information, participant information, and any third party that is helping to invest or transmit any funds for your participants relating to their plans, to know the right questions and to know the basic level of security that they should have in place is really what this is designed to protect.
Thank you.
All right, we're ready to talk about fiduciary oversight? It sort of tags onto what Abby was saying. And I just have one comment on the cybersecurity. This is one area where the plan sponsors and the record keepers, the trustees, everyone's interest is aligned here. The last thing Fidelity wants is a huge cybersecurity breach on their platforms. So this is one area where you really can be collaborative. But again, if your record keeper is not a plan fiduciary, so there is an impetus on those plan fiduciaries to reach out and make sure that your record keepers are taking the steps they need to take. And I have been really surprised at how quickly the Department of Labor is auditing plan sponsors on this issue. I thought they'd get out and audit the Fidelities and the Mercers and all of those entities, but I've been surprised at how quickly they're auditing plan sponsors on this. So it's definitely a hot topic for them, as it should be. All right, fiduciary oversight. This one is, we added this one. There isn't new guidance on this, but this is an area we have a client that was just recently audited on it. So it remains really high on the DOL audit list of items they're going to look at. As with most audits, it usually starts with a limited scope audit, which still feels pretty broad. But the deal with a limited scope audit is you have a very short period of time to turn it around. This client of ours, they got the letter from the Department of Labor saying, we want to look at all this information from you. I reached right out to the Department of Labor, and we basically had 15, maybe up to 20 days to get everything collected and into her so that she could review it and close it out. And she said, if I can't close this out by September 15th, we're going to trigger a full scope audit. Regardless of whether the information we ended up providing her was complete and accurate and answered her questions, basically, if we didn't get everything in by that time frame, no matter what, we were going to trigger a full scope audit. A full scope audit is very time consuming, and not something anybody wants to do. So when you get those initial inquiries, they come in as limited scope. It's just important to jump on them. So what do they ask for? I always, it's always helpful to know, well, what are they actually looking at? They wanted the list of the service providers. They had looked at the 2018 and the 2019 Form 5500, and they had gotten some information. So I couldn't tell what triggered it from the 5500. I think it might have been the administrative expenses, but this audit was purely triggered from the 5500. They wanted a list of the service providers. They wanted documentation of the administrative expenses, including the contracts and the invoices. They wanted details regarding the selection of the investment funds, including the committee meetings, the outside service providers, fiduciary reports. This particular client had an outside fiduciary that helped the client. They wanted benchmarking reports. They wanted QDIA information, so the qualified default investment alternative information. They wanted ERISA 404C compliance. So you can see this is limited scope, but this is pretty broad. They wanted the investment policy statement. So this is always an interesting one in my mind because technically ERISA doesn't require an investment policy statement, but the DOL always asks for it. And if you don't have one, I think it's a little bit of a red flag that you're not keeping a good eye on your plan. They also wanted very specific participant data. So luckily we were able to respond quickly, compile all this information from the record keeper and the trustee and the company, wrap it all up, put a nice bow on it, get it off to the Department of Labor, and we got a letter. They cleared us, which was, I had told the client, you don't usually get an all clear letter. I expected at least a more of a follow-up from them. I was hoping not to trigger a full scope audit, but we were able to get that clear. So again, it was a good example of if you jump on it, if you talk to the Department of Labor agent, if you're friendly and cordial and responsive, you can get out of these situations relatively unscathed. So the best practices from this audit for the fiduciary: quarterly committee meetings with good minutes. Minutes are really important. Make sure that you could prove that you are regularly reviewing your investment funds and have benchmarking included. You should be going out to your service providers every 3 to 5 years and getting at RFPs. It doesn't have to be 10 different, you don't have to go out to 10 different entities, but you at least have to go and make sure that you can be able to prove that you vetted the administrative fees that you're paying for your plan, for your participants are paying through the plan. The fiduciary should be making sure that your Form 5500s are timely filed. Your ERISA 4C documentation is in place. And I should have added, you're following up on your missing participants, and you are on top of your cybersecurity. You should have an investment policy statement, but you need to also make sure that your investment policy statement reflects what you're doing. You don't want a really old investment policy statement that's not in line with what you're actually doing under your plan. So that is a wrap up of the fiduciary oversight. I just wanted to touch on that since I did recently have an audit on that item. I guess it sounds like maybe there are a couple questions.
So I have one more question, and we'll circle back to it. It's, what are the common issues that bring a plan under audit?
So I can't, usually some things either a participant's made a complaint or several participants have made a complaint, or it's something in the 5500. It can be
Christine, such as the box maybe checked where you have had late contribution remittances?
100%. That if you check that box, you are going to get an inquiry. So it's important to jump on that particular area. But as I said, this one wasn't triggered by that at all. They didn't have delinquent contributions. It was triggered because the Department of Labor thought the administrative expenses looked high for this plan.
So it also, you mentioned on DB plans that if you have a lot of a significant balance in the terminated vested.
Yes.
And I've heard that in the past. So
yeah, I think that's exactly right. So that's, they're going to look at that. They clearly, I think the 5500s are the primary source of a lot of these audits now. They clearly are taking the time to review them. And I've had a couple clients where this most recent audit cycle had to disclose some things in the audited financials. And I said, you've got to expect that we're going to get a call. There's no way that you're not. I mean, maybe you won't. It'd be great if you didn't, but given how active the Department of Labor is right now, I think you really, that the 5500s is where they're gleaning all their information.
Right. So
I also wanted to circle back on that state sheet question, because I was sitting here thinking, I think one thing that had been unclear that I think is now clear is there's always been this open question about uncashed checks. So when you cash a check, when you cut a check, you issue the 1099-R, and then the check sits uncashed. The question was, well, is that still a plan asset, right? Because you made the distribution from the plan. The person never cashed it, but it technically came out of the plan, right? So at that point, does the state escheatment rules came into effect? I've never been, that had been an open question, and maybe it still is a little bit of an open question, but the Department of Labor clearly included uncashed checks in their best practices guidance that they just issued. So I take that to say that they think that uncashed checks are still plan assets until the participant actually receives the money. So I just wanted to add that nuance.
Thank you for that clarity.
Sure.
I know Brad will definitely sleep better tonight. So great. So I've got three key takeaway words. One being proactive. As plan fiduciaries, plan sponsors, those of us who are third-party providers, being proactive is key. The other word that has not ever stopped being used is documentation. What's in your mind isn't on paper, and I think it's just best practice to make sure you document the procedures and every, anything relating to the plan, the minutes, right? All of those have to be documented. The last guidance I would say is just being really resourceful and using the best practices guidance that has come from the Department of Labor on cybersecurity, on missing participants, showing that you're being very diligent. I think that is really, and also taking it very seriously, I think is very, very important in the process. So thank you so much, Abby.
Yeah.
Thank you so much, Christine, for sharing your guidance, your knowledge, just really great tips for those of us who are working with retirement plans. And, this information applies even if you're a qualified plan. I think it's really just great to have best practices. So really appreciate everything. Thank you so much. And thank you for
you.
those who attended. Have a great day.
Bye, everyone.
Bye.
Hi, thank you so much.